This is a state appeal, and we're asking this court to reverse the trial court's granting of suppression because the trial court erred and because officers had probable cause or reasonable suspicion to initiate a traffic stop. And
General Coleman, let me go ahead and ask you. We had this question in the back. Why is the state appealing this case?
so I think,
Because the charges, and I'll just go ahead and, is it truly for the legal principle? Because the underlying charges, in 6 out of 10 cases are a warning, maybe a cite, show up for court or pay online and we let it go. Why are we appealing this case?
So I think part of it is because this has an overarching principle, and yes, in this situation, the defendant had relatively minor charges, but in other situations, that might not be the case, and this court should reaffirm what the standard of review and what a trial court should look at when it is making a determination on suppression.
That's fair.
And so
So this is a probable cause case, right? Not a reasonable suspicion
I think
case?
ultimately, yes. I think the state at the trial court simply argued that the stop was sufficient. And so
It's kind of like a Davis case, right? Either the violation occurs or it doesn't. There's no further need for investigation under reasonable suspicion.
I think this court can easily find that this is probable cause.
All right, so as I understand the facts, there was not a one-way street sign on the road as the defendant entered it. Is that correct?
The trial court made a finding of fact. It's apparently a back alleyway, and that where you come in from what should be the exit, the court found that there was not a sign there.
Okay.
The defendant was driving the wrong way. When he came out of that alleyway, there is a one-way sign. And so the defendant is driving this way. There's a one-way sign pointing the opposite.
So if he were coming in the correct direction, there would have been sign postage or posted signage saying that the alley is a one-way street?
I think that's correct, but I want to make sure we're not going too far astray. And when we're looking at suppression, it is what the officer saw.
Well, I want to make sure I'm not going too far astray, because when I look at the statute, 558122, Part B, which I think is the actual operative language, it says, upon a roadway designated and sign posted for one-way traffic, a vehicle shall be driven only in the direction designated. So I think the issue of the sign posting matters, because otherwise you couldn't have probable cause to believe that a crime had been committed.
I would disagree. I think that the sign postage goes towards whether the defendant actually committed the offense. I don't think it goes to whether the officer could have objective facts which rise to the level of probable cause.
Well, let's assume that you have to have a sign posting for one-way traffic for there to be an offense for you to go down the wrong way. If an entire element of the offense is completely missing, there could not be probable cause, could there?
There could be.
There
If
could
the
be.
officer has subjective facts that establish that the element was there. And again, here what we have is the officer Mason testifying, I looked over, I saw the defendant's car, right in front of him was a one-way sign. There was sign postage there. So
Okay,
whether
I think maybe that's where I'm getting to ultimately. Was there a sign or was there not a sign?
where the Officer Mason saw the defendant, there was a sign.
Okay.
So Officer Mason didn't see the defendant enter the alleyway. He saw the defendant exiting the wrong side of the alleyway. Where the defendant was exiting, Officer Mason saw a one-way street, or a
So
sign.
is the state's argument then essentially, when you boil it all down, is the state's argument that the finding of fact that the trial court made to the contrary is not supported by the record?
No, I would disagree. I think the trial court's finding of fact is that the one-way sign posting was on the other side. We're talking about something that was not where Officer Mason was. So I don't think that that finding of fact has any relevance at all to whether Officer Mason had probable cause. Whether there's if there's no proof that Officer Mason knew or did not know about this missing sign, which the Officer Mason testified that based on his personal knowledge and based on his observations that was a one-way street, and never testified, never said, I knew that at the time of this infraction, or at the time I pulled the defendant over, I had personal knowledge that the sign was not there. I think if the trial court had made a finding that Officer Mason knew for a fact that the sign where the defendant came in was not there, that would be a much closer call. But that's not the finding we have. We simply have a finding that that other sign wasn't there. But when we're looking at suppression, we're looking at what Officer Mason knew.
So your argument really is the trial court's ruling is a defense to the actual crime charge of driving down a one-way street.
Yes.
And not a basis for suppression.
Yes, and that goes to the trial court's order, which says, the court's finding was there was no signage that would have alerted the defendant that he was traveling the wrong way down a one-way street, which is when he came into it. Without any such warning, the court is of the opinion that the defendant should not have to suffer the consequences of the traffic stop. But those are two separate issues. And so the trial court erred because the court ultimately made a finding of whether the defendant had committed the offense of driving the wrong way down a one-way offense, which he wasn't even charged and convicted of, or charged with anyways. But what the trial court's consideration should have been was whether Officer Mason and the objective facts presented had probable cause that when a defendant drives the wrong way down a one-way street and you see that signage posted, does that rise to the level of probable cause that the defendant is driving the wrong way down a one-way street?
So the sign the driver, under these facts, could see posted would be the back of the one-way street sign facing the other way.
That's a good question. I think the record doesn't.
What does the record say?
So there's the picture, the sign, I think, unless it's two ways, I think you would be correct. I just don't know. There wasn't a picture of the backside of that sign. So
I don't think you need to look in the rearview mirror and see you're going down a one-way street. So the sign would be somebody turning into that roadway.
I think that's correct. I just don't know if they could turn both ways so that it was posted for either direction to see. It's unclear whether the defendant saw. And the state's not arguing that the defendant at any point up until he was pulled over knew that he was traveling the wrong way. Again, when we're looking at suppression, all we're looking at is whether Officer Mason had sufficient facts to establish probable cause to initiate that traffic stop. And the facts here are pretty black and white. The defendant was driving the wrong way down a one-way street. Officer Mason knew it was a one-way street. There was a sign right in front of the defendant. Not that the defendant could see it, but that Officer Mason, looking in that direction, saw the defendant going the wrong way, saw a sign posted that said it's a one-way street, and said that I think the defendant is committing an offense.
I'm trying to figure out what authority posts a one-way street sign telling the people that are going the correct way that this is a one-way street. Maybe they do so you don't have to watch people coming at you or something. I don't know. It doesn't make any sense. The way I read the record, maybe I'm wrong, I sort of got the impression there was not a sign up at the other end. Another guy pulled in the middle, that this was the only sign.
So I think that's the factual finding, is that the end of the alleyway that Officer Mason was on had the sign that is admitted as a picture and as an exhibit. That is where the sign was. And it was pointing the way so that you would turn in to the street going the appropriate direction. But again, all we really need to look at when we're looking at suppression are the objective facts and whether Officer Mason, having seen those objective facts, had probable cause to believe that the defendant was committing the offense.
So it's different, but just bear with me for a second. Town that officer lives in, someone opens up a home daycare center. They haven't put signs up yet, but for whatever reason, the officer knows that's a daycare center, okay? Defendant drives by, officer knows defendant and knows defendant is on the sexual offender registry. Knows the defendant should not be within X number of feet of a daycare. Can he stop that person?
I think that is a closer call.
Because it's within what the officer knows. The officer knows that's a daycare center, a legally operated daycare. It's not just, a mom and pop shop. He knows. He was at the courthouse the day they filed the paperwork to get their state license. He knows it. But for whatever reason, they don't have the money, whatever reason, they hadn't put a sign up yet. And he knows defendant. Defendant drives by. Can he stop that defendant for that?
On a probable cause standard.
On a probable cause that he has probable cause the defendant is committing a violation of the sex offender registry by being within 500 feet. It's a closer call, again, because I think in that scenario, it is only in the officer's sort of subjective knowledge. Although I guess with the probable cause standard, we say if any reasonable person in that position. I think that would be. Again, it's very close, but I think that would rise to the level of probable cause. Now, if we were looking at a sufficiency,
Yeah, I'm not talking about
Like,
the
I think
actual
we're-
offense and whether
yeah.
they committed the offense. Because again, I think in this case, I think that the trial court, just in reading the briefs, relied too much on the defense to the offense in making his finding. I'm not saying he's wrong at the end of the day, but he relied too much on the defense to the offense. Which you would have a defense, in my hypothetical, of, look, they just opened up a day ago, I didn't know that, there's no way I could have known it, blah, blah, blah. But if the standard really is what is known to the officer at the time, and any person reasonably in the officer's position at the time, then that's probable cause.
and I think that's, the standard is whether a reasonable person in the position of that officer with all of the objective facts known would have probable cause. I think, in your scenario, it's closer, but that would rise to the level. Here, it certainly does, where we have not only the officer's subjective knowledge that the road is a one-way street, but simply just viewing a car going the wrong way in front of a sign that says one way the opposite way.
Well, he hadn't gotten to the sign yet, correct? I
He
guess he
was-
stopped there.
He was pulling out. He was very clearly traveling in the wrong direction.
So in your mind, does the sign matter at all? Meaning, does the state's argument go as far as to say, even though the statute requires for criminal liability the presence of a sign, and we'll take that as a given, that even if there were no sign, simply the officer's subjective knowledge that it's a one-way street would be sufficient for probable cause?
I think it would.
And I know we're talking about it being a defense rather than probable cause. I'm not sure that's correct. I wonder if it's just you can't make out the crime to begin with because an essential element's missing. But does the state's argument go so far as to say that even if there were no signage, the officer's subjective knowledge would give rise to probable cause alone?
I think so, Your Honor. Again, I think it
has
would be a
to be, right?
closer call, but yeah, if a reasonable person was in that officer's position and had knowledge that that was a one-way street and saw the defendant driving the wrong way, that would at least rise to the level of probable cause that he was committing the infraction.
Okay. So now, back outside of the hypothetical. If there were no signage on the street, then there could not be a crime to begin with. Do you agree with that?
I think if there were no signage anywhere.
Anywhere, right?
Then-
Let's say there's
then-
no signage anywhere.
Signage would not
There
have
could
been
not be
posted.
a crime, right?
I think that is fair.
All right.
Yes.
Can you have probable cause then if the officer subjectively knows it's a one-way street, but the statute doesn't create a crime unless there is signage? Could you still have probable cause to believe that a crime had been committed and that the defendant committed the crime?
I think then you would have to sort of dive deep down into, like, how does the officer know? Were there one-way signs that the officer was unaware of had been removed, or
Sure.
things of that nature?
In my hypothetical, I think I'm trying to address, not very well, I think I'm trying to address a situation where the crime is a factual impossibility. And so I think the hypothetical is, it's impossible to commit the crime under the circumstances because the condition precedent hasn't been satisfied. Can there still be probable cause to believe that a crime had been committed if the crime is impossible?
I think so, depending on how the crime becomes impossible. If that roadway had never been listed, never had signs posted, and that was just common knowledge that people kind of use that as a one-way street, then it would never have been a crime, and I don't think that the officer's subjective knowledge that it's a one-way street, when it's technically not, would rise to that level.
Okay, so we do, in fact, then depend then, with your answer to that, and I appreciate that, we do depend then on the existence of the sign. And so as Judge Holloway says, there would never be a sign at the end of a one-way street, right? You want to put a sign up where people are entering the one-way street from the wrong direction.
I would disagree with you, Your
Okay.
Honor. I think the signage can be posted in multiple places. So that
Probably could. So what authority do we look to then? Are there Department of Safety regulations about where and when you post signs? The statute itself just says where you have sign posted. So what source of law do we look to determine where the sign should be posted?
I don't think we look at that at all, Your Honor. I don't think I feel like that's a red herring. Really, what we're looking at is, does Officer Mason, with the facts presented to him, we know that there is a sign posted. Whether that is properly posted, sufficient to establish a crime that the defendant knowingly committed is a separate issue. But when Officer Mason sees a sign and knows, based on his knowledge of both signs being there at some point, that it is a one-way street, we have facts sufficient to establish probable cause.
Okay, so what if the red herring, if I go down that road just one more time?
Sorry, Your Honor.
What source of law do I look to see that in fact the circumstances were right for the commission of a crime?
I think you look at the offense itself.
Okay. And the offense itself says upon a roadway designated and signposted for one-way traffic. What source of law do I go to determine that the road was properly signposted for one-way traffic?
I think when you're interpreting that statute, you look at the plain language. There's a
Is there
sign
Is
posted.
there a regulation that we go to? As I said, do we go to the Department of Safety regulation? Do we go to surely not federal regulation? What source of law do we look to?
I honestly do not know, Your Honor.
That's fair enough. Okay.
I'm happy to do a supplemental brief if you want.
That's okay. No, I
but
appreciate it.
Yeah, I think the issue comes back to what Officer Mason saw.
Okay, so let me, if this had never been a one-way street, and the officer is just incorrect, but he thought it was a one-way street, do you think that's enough for probable cause?
Again, I think that is a even more close call. And
Well, I've tried a case
I don't.
like that as a trial judge, and I got it right. Except it was 45-mile speed zone, and he was doing 45, and he said it was 35, and it was actually 45, where the guy was doing 45, instead of a stop sign.
I think, again, when you're looking at whether a reasonable person in that officer's position with their knowledge, that might rise. That I think is almost right on the edge. And again, I just want to direct the court back to the facts we have here are significantly more bountiful than those facts.
I guess I just keep reverting back to the first question in this case. Why was this appealed? I mean,
That's a valid question, Your Honor.
So, General Coleman, I don't know if I'm going to help you or hurt you with Judge Greenholz's question, but the statute, he keeps putting it in there when he asks you the question. The statute does not say proper signposted, it just says signposted. So, that being said, his question is, how do we determine what signposted means? If the statute doesn't speak to it, do we need to go to another regulation, or are you correct? I know you're gonna tell me you're correct, but are you correct that, hey, it just says signposted, so if they wanted to put it, if it's on the top of a 50-story building that says, by the way, down there is a one-way street, is that okay?
I see my time's up, if I can briefly answer.
Please feel free to answer.
I think that depends on whether you're looking at sufficiency of the evidence for commission of the crime or whether an officer has probable cause. And if an officer, knowing the statute, reading that language, sees an individual and sees a sign posted, I think that rises to the level of probable cause. So again, we would ask this court to reverse.
At some point, though, and let me keep you just a little bit longer if I can, Judge Holloway. At some point, though, the posting of a sign in an obscure location doesn't comply with the statute. And so we're back into the realm of a impossibility to commit the crime. So for example, if it's posted way up high and I can't see it, fine. If it's posted a block away from the road, though, it's not satisfying the statute even under a plain language, right? I mean, I don't know what the purpose of the statute is. It doesn't really matter. We're governed by the language. But that wouldn't satisfy any purpose of the statute, right? So it does matter, doesn't it, even under a plain language, that the sign is there to alert the driver who's entering into the one-way street from the wrong direction?
When you're going to sufficiency, yes. When you're going to the probable cause of an officer, I think it matters that the sign was, that they either knew the sign was nearby or that they saw the sign there. So,
Okay,
so whether, yeah, thank you, Your Honors.
All right.
Don't worry, Ms. Butler, we'll try to pick on you too.
Never a question. Good morning, Your Honors. May it please the court, Jessica Butler with the Appellate Division of the Public Defenders Conference on behalf of the appellee, Mr. Poe. Before I begin, I want to just touch on a couple of the questions that came up during the state's argument. And I think the first thing that I want to talk about is this, this idea of a factual impossibility of committing the crime, to Judge Greenholz's question. I think Judge Greenholz is correct that there is an essential element of this crime missing. That if the state or the city has an obligation to adequately post signage and they fail to do that, then the public is not on notice about what the offense would be.
So, Ms. Butler, then we go back to Judge Dyer's question. He suggests that I am inserting words into the statute. Indeed, I may be doing it, absolutely. But with respect to proper sign posting, once again, what source of law do we look to determine whether the sign posting itself is sufficient to create the crime in the first instance?
Well, I do think that we should start with the plain language, and obviously it doesn't say adequate, but it does say that the roadway is designated and signposted to be established for one-way traffic. And I think incumbent in a plain reading of that would be adequate postage. That if in every instance, the state is required to notify the public of what the offenses are that they could commit. And generally, obviously, ignorance of the law isn't a defense, and we are all sort of expected to understand what the laws are at all times. But this is a situation where the law is not enforced simply because it's on the books. The enforcement of the law comes from it being on the books and also notice of where that would apply.
Well, I mean, it's the difference between knowing what the law prohibits and then knowing what factual circumstances exist that come within the ambit of the law, right?
I think that's correct. But I think in this instance, if there is no designation that this is a one-way street from the time that you are entering the street, then there's no way to enforce that law. There's no way to, one, be on notice. There's no way to enforce that law because there was never any given notice to begin with that this is a street that's been designated as a one-way street.
Well, let me ask you though, so let's say that using Judge Greenholz, trying to figure out where we look to. Let's say that the Department of Transportation has some guidelines that say at the entrance of a one-way street and at the end of a one-way street, there must be designation that this is a one-way street. So basically, requires two signs, okay?
Right.
And in your case, sometime before your client decided to drive down that street, day or two, some crazy teenager decided they were going to steal that one-way street sign. Has your client committed a crime or violation?
I don't believe so. I think.
Okay, so, and I don't know that I necessarily disagree with you on that, but I will ask this. But can the officer at that point still stop your client? Because under my hypothetical, some kid stole the sign 2 days ago. That officer probably does or does not know. Let's assume he doesn't, to make my hypothetical more difficult for you. He doesn't know that the street sign has been stolen. And therefore, here's an officer sitting there. Here's a car coming that the officer knows there was a street sign. There was a sign at the beginning, there's a sign at the end, and here's someone going down the wrong way down the street.
And keeping in mind that the hypotheticals addressed a probable cause
Yeah.
Right.
to believe that a crime.
I'm not talking about whether you have a defense to the actual crime, but does he have probable cause to stop your client?
I think that, I'm going to say no, and I think that to find that he does creates a really slippery slope. So number one, the officer, especially in this case, Officer Mason testified. He'd been on the force 12 years. He patrols that area regularly. So I think a reasonable officer should have known, in your hypothetical, that sign's not there. If you patrol the area regularly, any reasonable officer in your same position would also patrol regularly. You should know that sign's not there. So that would knock out.
Okay, but then what if he doesn't? What if it got stolen the night before?
What if he's just mistaken? What if he thought, and no, this is an important hypothetical, I think, because I think it really goes to the meat of the issue. So what if the officer's just mistaken? The regulation requires posting at the entrance and the exit of the one-way street. The exit of the one-way street, the sign is missing. The officer believed it was there at the time the stop was initiated, subjectively and in good faith. Is there not at least probable cause to stop the motorist? There may be a real issue with conviction, but is there probable cause to stop the motorist?
I'm still gonna say that there is not probable cause.
That's fine. What are the reasons? Why not?
I think because, and I do think there's some tension between what the officer knows and what the driver knows. And I think that's sort of where we're butting up against each other. But I think that there has to be some interplay between the driver is on notice that this is a one-way street and has, for whatever reason, gone down that street, and the officer knowing that that's a one-way street. I think we have a dicey situation where the officer.
Sure, but probable cause, I didn't mean to interrupt. I'm
No,
so
that's
sorry
fine,
about that.
that's fine.
Probable cause doesn't depend upon the subjective knowledge of the defendant or the person being stopped. It's an objective standard just under the statute, right? You know, is there probable cause to believe that a crime is being committed, and if so, is the defendant committing the crime? Under that standard, it doesn't really particularly matter whether the defendant subjectively believes that she's complying with the law or not.
Correct, but I think
So-
also it doesn't matter that the officer subjectively believes that the sign is there. That the officer in that position should know there needs to be 2 signs posted. There's not a sign posted. Whether the officer is mistaken or not, I think the question is, would another reasonable officer be mistaken? I think in this case, not necessarily. The officer did say he knew the sign wasn't there. He couldn't say how long it had been down, but he knew that it wasn't there. And in fact, it was still not there a year plus after the fact, by the time we got to the hearing. So I think an officer in that position objectively should know that the sign's not there, and their subjective mistaken and understanding shouldn't come into play in terms of the probable cause analysis.
So you believe the record has the officer testifying affirmatively that the officer knew that the sign was not there at the exit of the road and had not been there for as much as a year?
I think it's less clear that the officer knew the sign was not there at the time. The officer was very clear about saying it was not there. It's not there. It hasn't been there for some time. I'm not sure how long it hasn't been there, but it is definitely not still there.
Was it ever there according to the officer's knowledge?
The officer never testifies. I don't believe the officer ever testifies there's a do not enter sign there at some point. The officer just testifies that I know it is a one-way street and there is not a sign there. I take that back. I think the officer does say there was a sign at some point, but it's not there now. I don't know how long it hasn't been there, but it's not there now. And again, this is a year plus after the fact, so.
So, okay. It kind of goes back, again, let's go back, dive into Judge Greenholz's question of how do we determine, where do we find the right definitions for these things? Again, the statute just says upon a roadway designated and signage posted for one-way traffic. There is a sign. I mean, I get it. There's not a sign back here, but there is a sign over here. Plain reading of the text of the statute, that roadway is designated with signage. Is there something else you can point to that says that's not what that means?
I think really what it all comes down to is there a requirement, is there a regulation, is there a
Yeah.
principle of law that says that there must be a sign at the exit of the one-way street?
I get best practices might say that, yes,
Sure.
you should have mark it everywhere.
Right.
Yeah.
But is there something that actually says that? Because, again, we're looking at the, even if you want to say the subjective reasoning of another officer, if the statute says signage posted and he knows there's a sign there, one, I know it, and I also know this is a one-way street, I don't see how you get around him not having probable cause.
So, in terms of what the plain language of the statute, I'll start there. So, I think when you read designated and signposted, I think incumbent in that reading is designated and signposted in a way that motorists are on alert that that is a one-way street. If it's designated and signposted elsewhere, it's not doing its job in terms
It
of.
is in this case, I mean, I understand where you're going with this, I'm not, I'm continuing to play devil's advocate with you, but it is in this case. It's not like it's posted 2 blocks over that says, oh, by the way, 3rd Street's one way. you're on Fifth right now, Third Street's one way, you better figure out a different way to get to where you're going. It's on, I'm just gonna call it Third Street still. There's a posted sign on Third Street that says this is a one-way street. So even under the public has to be on notice, they're on notice that Third Street is a one-way street. May not be at the best place on Third Street, but the statute doesn't say at the best place. It just says designated and posted.
I still think that incumbent in that reading of designated and signposted is designated and signposted in a way that alerts the motorist driving that it's designated one way. And if you are only alerted that it is one way as you are exiting the wrong way, then that sign is not doing what it's supposed to do. And that's the problem I have here. It's Mr. Poe is not alerted that this is a roadway designated and signposted for one way until he has already traveled down the street.
So I guess that gets back to Judge Greenhold's question. Is there a regulation? Obviously, you don't know, and neither
I do not,
and
and
neither does the state. I'm not blaming you. But is there a regulation, something we can look to that says this is what a posted and designated street is?
I mean, there has to be, right?
I'm certain that there is. I will be honest. I didn't go that deep when I was
Let me
preparing
ask
for
you this
today,
question.
but
He didn't cite him for the traveling the wrong way on a one-way street. This was an alley in the city of Jackson. He was stopped by a city officer, cited to city court on a state warrant on the other charges. Would Jackson city ordinances and their rules of the road be the appropriate definition to determine whether this was a one-way street or not?
potentially. My guess would be that it would either be Jackson City ordinances or Department of Transportation, Tennessee Department of Transportation regulations. Obviously, there are do not enter signs that are posted all over the place, and those have a purpose. So I would imagine, like I said, I haven't done the research, but I would imagine that the Department of Transportation or Highway, those regulations would instruct the court about where and when a do not enter sign is supposed to be posted. And my assumption would be that this would be the type of scenario that one should be posted, if for no other reason, at some point in the past we know one was.
I don't know if this is what Judge Holloway was asking, but it is, as he points out, a Jackson alleyway in the city of Jackson. Does the Department of Transportation have any sort of authority over how the city of Jackson marks its alleyways?
Well, I don't know.
So even if we went to a Department of Safety or Department of Transportation regulation, would that even provide us any true guidance? Because it is just an alley in the city. I know you haven't, Deb.
Well, and let me add on to that a little bit, because if the citation is to a Jackson City ordinance, that's a civil violation. How does that play into the probable cause analysis, which requires probable cause to believe that a crime has been committed?
That would go to the Court of Appeals. I've sent Judge Stafford. With a lot of pleasure.
So is it your position that the citation actually was to the Jackson City Court on the failure to observe a one-way street?
Well, he was never actually cited for failure to observe the one-way street, which is, I think, again, part of sort of the confusion here is he wasn't actually cited at all for violating this ordinance, this violation.
Is there anything in the record that shows this is a public street instead of a private alley?
I don't believe so. I would have to go back and look. There is some discussion, I remember, early on at the suppression hearing about the sign, and it may have come up at some point that it was a public street. I'm not sure.
The statute requires it, so 558122A only permits the crime to be committed on a street that is under the jurisdiction of the Department of Transportation.
Correct.
So what proof is there that the street was under the jurisdiction of the Department of Transportation? Maybe a question to ask for the state. but
I don't recall that there was any testimony about the fact that it was a public street. Like I said, I do remember there was a good bit of discussion about the sign itself, but I don't know if that specific question ever came up. I mean, my sort of immediate reaction would be that it is likely a public street and it is likely under the control of the Department of Transportation, but I don't believe that that specific question was ever addressed at the suppression hearing.
Butler, can we split the baby here? By that I mean, a suppression hearing, the state is required to establish all these things, basically, that we've been asking about, to establish probable cause. You kind of listen to our questions, there might be some holes here. But would you not agree that the trial court's ruling that and I'm going to butcher however he said it, but the defendant shouldn't be punished for their lack of knowledge is not really the correct answer. The correct answer is the officer lacked probable cause for these and these reasons. So when I say split the baby, could we not say the trial court's wrong, but even in being wrong, hey, the state didn't meet its burden?
And I think that is a fair position to take. So the first thing I'll say about the trial court's ruling, and I know that there's some argument from the state that really the trial court never actually addressed the probable cause determination. I think to some extent, I think the ruling itself is an implicit ruling that the state did not establish probable cause. But to your point, I think the first thing that I want to point out is that, yes, on a suppression motion, it's the state's burden to prove that they have established probable cause. And obviously, the trial court made a finding that they had not. The second thing I want to say is that I do think that the trial court is sort of wrestling with this question, and there does seem to be, I think, a fundamental fairness issue to this. It's the city or the state's obligation to maintain signage. And if they don't do that, I think there is a fair question about whether or not Mr. Poe or any other member of the public should bear the consequences of the state or the city's failure to do
That's not a
that.
probable cause analysis, right? That's a fine policy argument. That's not a probable cause analysis, though.
But I do think in
Because
this
that doesn't fit
instance,
into any of the probable cause.
I do think in this instance that is a proper consideration, given the fact that the
About what's
entire
fair to-
basis for the
about What's fair
stop.
to the defendant is appropriate? It wouldn't be the case with the counsel.
I do think that's a fair, in all seriousness, I do think that's a fair question, is that essentially what we have here is if this stop is deemed valid, so again, a year plus after the fact, there is still not a sign there. So we have a situation where an officer can say, well, I knew at some point that, I always knew that this was a one-way street. And they can just sit there and pull people over left, right, and center because it's a one-way street, but there's nothing indicating to the public that it's a one-way street. And I do think that that is a consideration for the trial court to make, even as it's establishing this probable cause argument, that if the state's not doing its due diligence to inform the public that this is a one-way street, and the officers are using that to their advantage to pull people over.
I agree with you, but see what the underlying assumption is, though. The underlying assumption is that there is, in fact, a violation of the law because, in fact, there was required signage to be posted at the exit of the one-way street. The entire argument presupposes that critical fact. I think what we were asking here today earlier is from where do we get that critical fact? It looks like the Department, I have to assume the Department of Transportation has regulations that address what appropriate signage is. I'm curious about whether it matters in terms of the probable cause analysis. But it looks like the fairness argument really depends upon that one fact, in my mind. Is that, well, he didn't know because it wasn't properly posted, and that assumes that there was a requirement that there be a sign there. And so once again, it's not fairness to the defendant. We're just looking to see whether there's probable cause to believe that a crime had been committed.
Sure, I have 5 seconds left, so I'm going to try to make this very quick. But I think generally the question for the court is, if there is not a sign posted alerting the public that it is a criminal offense or it's a violation of the traffic laws to drive down this one-way street. If you drive down that one-way street and there's not signage posted alerting you to that fact, have you still committed a violation? I think that's ultimately the question for
Or
the court.
is there probable cause for an officer to believe that you've committed the violation? That's really the question, right?
We're not as concerned about what's in your mind as the driver. We're concerned about what's in the mind of the officer at the time.
What the objective facts
I
are.
get your fairness. I'm with Judge Greenfield. I get your fairness argument. I get that and I know you're out of time.
Yes.
So, but this is on us. Is that the officer testifying, hey, look, at your hearing, since the date of this stop till now, there still isn't a sign. That's a lot of great defenses to future potential probable cause issues, and definitely defense to a future stop and a citation. But I'm not worried about that. I'm worried about what the officer knew at that time, at the moment your client drove by him. And that's all I'm worried about. I don't say this, I don't mean as flippantly as it sounds. I don't care what your client thinks at this time. That's not the analysis. The analysis is, what did the officer know at that moment? And here, at least, it looks like there was some sort of signage, which therefore complies with the statute. The officer knew it was a one-way street, and the officer knew your client was going down the wrong way down a one-way street. How is that not probable cause? Forget all the other stuff. I'm talking about in the vacuum here. The officer knows these, and these things. How is that not probable cause to stop your client?
I will still say.
It's a great defense to the actual conviction.
That I think that you cannot assume that there has been criminal activity committed if there's not a sign indicating that driving this way is criminal activity. And that's where we have the problem with the
Because that's the
basis for this
critical
stuff.
fact that underlies his hypothetical, right? You said the
Correct.
sign on the entrance to the one-way street
Correct.
is appropriate signage in the language of the statute.
Right. So I think it comes down to, is there appropriate signage? Number one. Two, if you are not alerting the public that that this is a one-way at the entrance or the exit, I suppose, that Mr. Poe entered, is it still a violation of the statute if he's not on notice that this is a criminal act? And if that's the case, then I think an objective officer should know that absent a sign, an appropriately placed sign, that the individual has not committed a violation.
Thank you, Ms.
Ultimately, we'd ask the court to affirm the trial court's suppression. Thank you.
Thank you, Ms. Butler. Thank you.
General Coleman, as you walk up here, I want you to be thinking about this question. As someone who has stood behind that podium where you stand for many, many years, there was always a premise in the back of my mind that bad facts make bad law. You got bad facts here. Do you really want us to be trying to determine probable cause based on this case? Why are we here?
What's the holding that you want the court to reach? Simply that there's probable cause to initiate the traffic stop?
Yes.
Nothing more than that?
Yes, Your Honor. When an officer sees that an individual is traveling the wrong way down a one-way street, sees that individual in front of a one-way sign, and has personal knowledge that rises to the level of probable cause.
Okay, so really what the state's looking for is that the officer's subjective knowledge that a crime is being committed, even if it's possible that the crime could not be committed, as a matter of fact, would give rise to probable cause. That's really the holding that the state is seeking, is that right?
I think based on what that subjective knowledge is based on, yes, Your Honor. The defendant talked about factual impossibility to commit the crime, and that is a wholly irrelevant consideration to whether the officer, with the knowledge and with the facts presented to them, had probable cause that a crime was being committed. It might turn out that wasn't being, the crime was not being committed. That's not what the issue is. The issue is, does an officer have probable cause when they see these facts that rise to the level?
So it's maybe stated another way. If it turns out that the crime could not be committed as a matter of law because appropriate signage was not placed, the officer still could have probable cause if the officer believed it was a properly designated one-way street.
I think so.
That's the holding that the state seeks.
If the officer believed that it was properly designated, then yes,
Even if a crime could not be committed as a matter of law.
correct.
Okay.
That is my understanding of the law, and that is what the whole basis of probable cause is. If the officer in good faith has the knowledge and sees these facts and believes them to be a crime that is an actual crime, not
No, that was
made
my
up.
hypothetical, it's not an actual crime.
That's where he's catching you.
Yeah.
I think
I'm
your
asking if-
hypothetical is that the facts later arising.
I'm saying that as a matter of law, the crime could not be committed. Because in this case, there's not appropriate signage. As a matter of law, it could not be committed. And I was asking, is the holding you're seeking from this court is that you could still have probable cause to believe that a crime was being committed because of the officer's subjective knowledge?
If the facts presented to the officer establish that the crime could have been committed, then yes. Because that, we're only looking at what the officer's knowledge. So if the officer sees this and all of their knowledge is that, then yes, that's probable cause. Again, if it, as a matter of law, could not have been committed, then the defendant can't be convicted of that. But that doesn't go to whether the officer can initiate a traffic stop. Briefly, I wanted to address a couple of the questions here. Yes, the officer explicitly testifies on page 11 of the transcript. There used to be a red and white "do not enter" sign at the other end of the alley. Officer Mason testified he didn't know when it had disappeared, but indicated, or well.
Mr. Coleman, I want to ask you about, and this may be a case in your favor. We'll give you, but anyway, I was recently on a panel where the person was stopped for not having an illuminated plate light. And if you've read that statute, you're familiar with it, there's a lot of exceptions to, when the vehicle was made and these types of things. Well, after he stopped the vehicle and found all the drugs, it turned out that that vehicle was exempt from having an illuminated plate light. And if I recall correctly, we found the officer had probable cause or reasonable suspicion to stop that call. And the officer was wrong. I guess that's not a mistake of law as much a mistake of fact in that case. I was trying to just think how that would relate to this case.
Well, that case is a reasonable suspicion case though, right, Joe?
Yeah,
And
probably
here we're
reasonable
dealing with a probable cause. Either the crime, it's like Davis, right? Either the crime's committed or it's not committed. There's not a reason to investigate further about going down a one-way street as there might be with a light on a tag. So it's not a reasonable suspicion case. Yours is a probable cause case.
I think you're correct, Your Honor. I don't know if the other offense was this court found probable cause or reasonable suspicion.
Maybe reasonable suspicion in that case.
But again, state would simply submit that when an officer has these objective facts, that rises to the level of committing a violation of a state statute, not of a civil ordinance or anything.
Okay.
And for that reason, we ask this court reverse. Thank you.
General, thank you.
All right. That concludes the morning docket. We'll be adjourned till 1:30.